time to talk about Colorado.
You have no idea how many times I've been on crazy, super high profile, ridiculous murder cases, and the focus of my testimony has been on my associate's degree. I've never had a judge really take on this adversarial role with a witness before. He came out and just completely filleted me. It's pretty harsh.
And who is this judge?
Judge Juan Villasenor. The judge is going to cite 3 cases that support his opinion that my methodologies and the TRACS program have been thrown out of court before, and they support him throwing it out of court as well. Are you ready for these 3 cases? Let's talk.
For law enforcement, cell phone data is a powerful new tool.
The Supreme Court ruled that cops need a search warrant before getting data from your cell phone that shows where you were and when.
In a 5-4 decision, the Supreme Court said it's such a detailed record of our movements, it nearly turns a phone into an ankle monitor.
Welcome to Socialite Crime Club. Let's air out Colorado. It's time.
Can we talk about clown shoes instead?
No, we'll save that fool for next week. It's time to talk about Colorado.
Colorado versus Christopher Jones.
Mm-hmm.
It's got a lot of attention.
Does have a lot of attention. You are quite the subject of scrutiny in this matter.
Yeah, so let's talk about Christopher. Number one, this is a 2022 case. I believe this was August of 2022 is when this hearing happened. Christopher Jones, fairly common name, so we don't have to identify any individual necessarily, but just Christopher Jones in general. He was charged with 3 counts of stalking, and this is all related to a violation of an order of protection, which also triggered a bond issue.
Okay.
So if I'm reading the history back, and we'll get into why I have to read through this history, Christopher Jones and his fiance broke up. There's something that happened that he got into some trouble. She files an order of protection.
Okay.
I think he must have got arrested because there's bond in place. So clearly he had to bond out.
Mm-hmm.
Allegedly, he violates this order of protection she has, which triggers the issue with the bond as well. So he's getting the stack of charges of stalking, which is also a violation of the order of protection, which triggers the bond. If that makes sense.
That does.
So if the stalking charge goes away, everything else falls off as well.
Sure.
Makes sense?
Mm-hmm.
Far as, and this, I know you're going to ask me because you always do. I don't know the other issues with him and his fiance. I don't care. It's not my business. I'm not going to get into that. Okay.
But it's just so.
I know it's juicy, but I'm not getting into it. I don't know what it is.
Okay.
Here's what you need to know. She reports to law enforcement that she saw Christopher Jones drive through her apartment complex, dun, 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 in violation of this order of protection.
And how so? Is there a certain amount of feet that he can be from her, or?
That's a good question. Yes, 50 meters. So I think maybe it's probably 50 feet because it's a U.S. court. So it's probably 50 feet. She can't, or he can't be more than 50 feet from her or her apartment. So even if she's gone, he can't be within 50 feet of the apartment.
Okay.
Which is kind of weird too, because I don't know, driving through an apartment complex would necessarily violate the 50-foot rule. You'd almost have to drive right by, unless the entire complex is protected.
Right. I've had similar issues come up where a woman had an order of protection against her spouse, and she actually called him into the police because when he dropped off their child for their custody exchange,
he violated.
He parked on the wrong curb, which put him closer to the house.
Yeah, absurd, right? And there's always layers of nonsense within this, and we probably should clear this up a little bit. I think where law enforcement attached to this really quickly, like, oh, even if he's close to the apartment, there's an issue here. Mm-hmm. Christopher lives in Cheyenne, Wyoming.
Okay.
The fiance lives in Fort Collins.
So that's about, what, in half an hour?
Yeah,
40
so
minutes?
I think they're thinking, hey, if he's just anywhere near the apartment complex, why would he drive all the way from Cheyenne to this apartment complex, unless, of course, it was to stalk her. But there's some information that needs to come out with this. Christopher has a job in Johnston, Colorado, which is just east of Loveland. So it's south of Fort Collins.
So it's a little bit further. It's about an hour 15
so
maybe?
Every day that Christopher goes to work, he drives from Cheyenne through Fort Collins
to Loveland. Okay.
So he would have a reason to be there if he's coming and going from work.
Sure.
The other issue with this case, Christopher Jones is a driver for FedEx. His route includes the city of Fort Collins. Okay. He has a reason to be driving around Fort Collins. Now, she's going to say, I didn't see him. I just saw his truck. It's a red Dodge truck.
I want to clarify, go back. So you said because he has a job at FedEx, he would have a reason to be there. He would have a reason to be passing through the Fort Collins area to get to Loveland, not to be at her.
His delivery route includes the entire city of Fort Collins. Anybody who sends a FedEx package to any address in Fort Collins, he could potentially deliver it.
Right.
So I also need to clarify the sighting of the truck. She didn't see Jones. She didn't see him driving. She saw his truck, and she describes the truck as a red truck. Fort Collins does a little bit of research, and they figure out it's a red Dodge truck. So Fort Collins PD is going to do the investigation.
I have a question. Did she see the truck from outside of her apartment, or was she inside her apartment when she saw a red truck passing through the parking lot?
I don't know. In the report, it says that her and her son saw this red truck drive by. Okay. Where they were at in the apartment complex, I don't know. I do know that their view was blocked enough that they could not identify a driver.
Okay.
So as Fort Collins begins this investigation, they find that the apartment complex has video surveillance.
Okay.
So they're going to pull video surveillance and they're going to review it. And sure enough, around the time she says this red truck comes by, there is a red truck going through the parking lot.
Okay, so they did some due diligence.
They did, except for the problem is it's a red Toyota. And Christopher Jones drives a red Dodge. In addition to it being the wrong make and model, it has a camper shell. And the victim in this case even admits, no, he doesn't have a camper shell. So they know it's not his red truck at that point.
Okay, so closed. We're good.
Yeah, you would think, right? That was going to be my next question. What do you do in this investigation at this point? You have this fiance who has this order of protection who calls law enforcement and says, hey, this guy drove through my apartment complex, violation order of protection, or you realize it's going to cause all these other issues, stalking, violation order of protection, the bond thing.
Right.
You pull the surveillance video. It's not his truck.
Okay.
Close the investigation.
Yeah.
It's done. The officer in this case is going to write a search warrant at this point for Christopher's cell phone records.
Okay. Why? Under what probable cause does he have the ability to write a search warrant for cell phone records at this point?
I'm going to make an assumption, which probably means I'm going to be wrong here. There is some other case that was adjoined to this case that Christopher was being looked at for. I haven't read the probable cause for this search warrant. I don't know what it is. I suspect it's heavily reliant on this other case, whatever this other issue is. And I don't know anything about this other issue, so I'm not going to even try to allude to what it may or may not be.
But we don't even know that for sure.
All I know is that the patrol officer writes a search warrant for Christopher Jones' phone records, and according to some judge somewhere, he had probable cause to establish that. So they're going to get Christopher Jones's Verizon records. Okay,
but that doesn't mean that they are relatable at all to what is happening with this particular incident of her reporting him driving through her apartment complex.
Not only are they going to get the Verizon records, they're going to analyze the Verizon records to see if they can put him at the apartment complex for this violation of order of protection.
Oh, this is shady.
Yeah, there's some problems here.
This is not good. Who is this? How long has this person been an officer?
I don't know. He's a patrol officer. I don't think he's been through any real cell phone training. And I'm going to get into that here in just a minute. I've got a picture for you here in a minute. He's going to map the records. And the way he maps the records, he uses our system, the TRAX system. Fort Collins was one of our customers, so they're using the TRAX platform.
We actually had some really good subject matter experts there.
We did, but he left to start an automotive shop. I'm still mad at him about that.
Who leaves law enforcement to start their own business?
He was a really good detective.
He was a good detective.
Long story short, this is not within best practices. Like, we would not recommend this. We haven't recommended this. We've testified in the past, this isn't really what you want to do here. But this officer sees that Christopher Jones's phone is in the general area of the apartment complex and decides, oh, he was there. He did it.
I think that's quite common, actually, for a lot of people to do that without the proper training.
It is. And we're going to talk about this a little bit more here in a little bit. And I've got this picture we're going to put up on the screen here. What you're seeing with this red overlay right here, that is our estimated handoff area is what we call it. And it is a general estimation. It is not exact. It's not precise. It never will be. We've never claimed it to be exact or precise.
No.
What we're saying is, hey, most likely that phone is within that red shaded area for at least a brief period of time.
You need a lot of other data and potentially corroborative evidence to put somebody at a specific location at a specific point in time.
We're going to come back to that, but it's really interesting. If you look at these records, I could tell you right now, that this phone is probably on the freeway that's going up the middle of the screen. That's I-25. The call prior to this was actually quite a ways to the south.
Well, the azimuth line is headed directly towards the freeway.
Yeah, and for those of you at home that don't know what azimuth is the direction that the antenna is pointing. You kind of see a black dot at one side of that overlay, and then there's a black line that extends across there. That black line is representing the direction that the antenna is facing. And the problem here, and it's really clear when you look at the records holistically, is the prior call was south quite a ways. The only way he's getting from point A to point B in Fort Collins, anybody who's driven through Fort Collins, he's got to be on I-25.
Right.
I have a little icon here, a little house icon. That's where the victim's apartment complex is. So based on this image...
Well, she's not a victim, really, because...
She's got an order of protection. She's a victim.
Right, but he didn't drive by her house.
She's not a victim of this crime. Well, we don't know that yet. You're jumping ahead.
Well, based on what I know from the evidence.
So basically what's going on here is based on what you see right here, they filed the charges. I would not have done this. I would not have recommended this. And
this
I would
is
actually
very reckless.
I would actually testify against this. If I saw this happen, I would be like, no, you don't want to do this. This is not a good thing to do.
Right.
Jones has a little secret, though, that I don't know, either they didn't know or they just weren't paying attention. And Jones comes up with the classic defense, wasn't me. Mm-hmm. And I can prove it. And what Jones says is, hey, I'm driving a FedEx truck. My FedEx truck that day has GPS. So this little picture right here, the date and time of that connection right there, I'm in my FedEx truck. My FedEx truck has GPS. Oh, by the way, here's the GPS.
Oh.
So he provides the GPS.
And typically any type of fleet GPS is very precise.
3-meter accuracy. It's like what you get when you're doing turn-by-turn navigation in Google.
Nice. Okay.
So I'm going to add to what we've got here. Notice we're back to this picture. You can see the red shape there on the screen. Mm-hmm. You can see the victim's apartment. And to your point earlier, if you follow that black line that goes through that overlay, past I-25, there's an intersection up towards the top there. It's got this red dot on the right side or the east side of the freeway up there. Mm-hmm. That's a business complex where Mr. Jones is making a delivery to a business.
At and around the time that she was saying...
At the exact same time.
Oh my gosh.
And he's in his FedEx truck. He's not even driving a red truck.
And we can corroborate him being in his FedEx truck with him clocking into work that day, I'm sure.
Not only clocking into work, but all the deliveries he made, like they give him the little pads. There's no doubt he is
like
working.
When Amazon takes a picture of the package that they deliver at your door and shows the time that it was delivered.
Exactly. 1,000%. There's no doubt Christopher Jones is working that day. He's in his FedEx truck. He's making deliveries. And that red dot east of the freeway is where he is at the time of this delivery.
Got it. Oh my gosh.
Tracking?
Yes, I'm tracking. This is a terrible investigation on behalf of this officer.
It goes forward.
Which makes me very angry because you've eaten 1,000 shit sandwiches because of his poor work product.
We'll get to that. You're jumping ahead again.
I did not know most of this.
Yeah, and that's interesting. A lot of this has never gone out. The mainstream media really picks up bits and pieces of what they want to report. They want that headline. And we've got an episode coming up about headlines and why you got to be really careful with headlines. But I think most people in America are these days. But more importantly, there's a lot about this case nobody knows because it's technical, it's complex, and it's much easier just to talk a bunch of crap than actually dig into the truth of what happened on this case.
Sure.
But they follow through with this. And it is beside me, and I don't know all the details of this
investigation.
investigation.
You mean they follow through with using the phone records?
Yeah, they're charging him. They've indicted him. They're going to court. And again, I'm going to clear myself a little bit from being too judgmental of that because I don't know the other case. I don't know the underlying case that they're also looking at. And I had nothing to do with this case at this point. So I'm fat, dumb, and happy in a whole different state. I know nothing about this case at this point. I'm just kind of doing my own thing. Now, I want to clarify, mistakes happen. I have screwed up cases before. Right? It happens. You overlook something, you didn't find something, you thought you saw it one way, and then you look back and, oh crap, I was wrong.
Sure.
And obviously the thing to do is say, I'm wrong. At the end of the day, everybody's human. We're all going to make mistakes. You got to just own it.
Well, and you do that prior to trial. You talk to your prosecutor.
Preferably you do it prior to trial. Yes. Yeah. So law enforcement could have seen this and been like, oh, you know what? We're wrong. We don't want to proceed with this charge.
Very strong evidence. We didn't really understand what we were doing with this evidence at that point. Let's not put
Let's back off. And while I can't say every time that ever happens, a prosecutor necessarily would pull back, I can't imagine a situation where a prosecutor takes a case to court knowing that the law enforcement agency that investigated the case is saying, ooh, we got it wrong. Like that just doesn't stack up.
And then
well.
the agency actually get on the stand and continually be supportive of what that evidence was and what the prosecutor is trying to prove.
At the same time, the prosecutor also has a duty to review the evidence, understand the evidence, and also say, I don't think this passes the muster here. Like we're not going to move forward on this case. We don't want weak cases in court.
Sure.
Neither of them do this. And the defense kind of takes a hard line and says, hey, fine, you guys want to go to court? Let's play. And this is where this case starts to go south.
Had the GPS data been released to the state at that point?
I don't know at which point in time the GPS data is released, but at some point prior to trial, the GPS data is known and it is released. And I can't tell you the exact timeline there. Now, there is a motion that the defense can file anywhere in the United States, and it's a challenge to scientific standards. It's basically saying, hey, you're using this technology as evidence, and we're questioning the reliability of that evidence.
And every state has a different version or uses a different version of this scientific standard. So a lot of times it's a Daubert standard. In Colorado specifically, it's a Shrek hearing.
Right.
In California, I think it's a Kelly motion. Yep. There's also a Fry standard.
Correct. So, and depending on where you're at, federal or state can be different as well. And they're all relatively the same or very similar. There's a few little pieces, and it's all case law. So Daubert, Fry, Shrek, Kelly, it's all cases that had some type of prior precedence in that state.
Overall, the encompassing need for them is to some piece of evidence into court and show that it has scientific validity to be upheld with as evidence.
Right. It's reliable. We can depend on it. And I want to make something really clear because we're going to start getting into some technology, some science, some background science. Hey, J for Justice, I believe in science. There's this other podcast. I'll let you explain it. I know you've been dying to.
She either misunderstood or intentionally adulterated one of our episodes, our tea room, where I told Cy that he doesn't believe in signs, as in S-I-G-N-S. And I thought it was pretty clear based on the context of what we were speaking about.
But then I repeated it and I said, you're right, I don't believe in signs.
Maybe she misunderstood, but she said that later on, Cy doesn't believe in science, as in S-C-I-E-N-C-E. And she had a lot of people viewing that day, but
she's like 100,000 followers. So there's probably 100,000 people running around the country thinking I don't believe in science, which is, I did email her and ask her to please correct it.
Did she respond?
Of course not.
Of course she didn't.
Yeah.
Well, I'm hoping that her listeners just use her podcast as more of a form of entertainment, paparazzi style media, and have actually done their own due diligence and come to visit Socialite Crime Club to see the unadulterated version of what we said.
Defense has got a problem here that they have to show that the cell site location information, typically referred to as CSLI, is incorrect. Hey, this mapping that the state is relying on to show that he's in the area of the apartment complex, it's inaccurate. They take this into court and say you can't rely on cell site information. And the judge pushes back pretty quickly and says, hang on. The Supreme Court has actually said cell site location information is reliable. In fact, the Supreme Court, it's Carpenter, US v. Carpenter. The Supreme Court's come back and said it's so reliable that law enforcement, you have to have a probable cause search warrant to get that information because you're creating almost a breadcrumb-like trail of where somebody is day in and day out.
Well, it creates such a good picture of what somebody does day in, day out of their life that it is very comparable to getting a search warrant to go in and look through somebody's underwear drawer.
Right.
The intimacy of what you can find out about a person's everyday life through cell site location information is absurd.
So at that point, the defense changes its argument and says, okay, we're not going to attack cell site location information. We'll just attack the mapping, which in this case is the TRACS program. So in court, they start talking specifically about the mapping. At some point, somebody brings my name up of, hey, it's this guy who created this travesty of a program. He's the guy. And the judge actually tells the prosecutor, hey, if you want to go on with this hearing, I need to hear from this guy. This guy needs to come in and testify on this case.
And who is this judge? What's his name?
Judge Juan Villaseñor.
Okay.
So I get a phone call out of the blue. When I say fat, dumb, and happy, we went through a little bit of a
transition.
I call it a sabbatical.
It was a life transition.
Yeah, we had sold our business and we weren't sure what we were going to do next. And we were just kind of hanging out. I was trying to get out of court. I was kind of done with testifying. And we get this phone call. I had about a 2-day notice of, hey, you have to testify in this case to explain the TRACS program. We don't need any testimony about the investigation, nothing about law enforcement. We just need you to talk about the TRACS program. I'm like, okay.
I think I do remember us sitting down drinking wine and talking about what we were going to do with all of this new spare time that we had.
Yeah.
It's really exciting.
Yeah, that didn't work out.
And then it got depressing.
So basically what I'm being told is that in Colorado, there's a Shrek hearing, which is the scientific challenge. And I am being requested by the judge to testify to how the TRACS program works. And that's it. That's the only thing.
Okay, but that's not uncommon. You do that all the time.
Yeah, and it's super, super common. In fact, we do it so much, we've created a website, and we did this years ago, called standard.zetx, ZETX.com. It's still there today.
It's pretty much accessible for anyone to go view.
It is public facing, and we did that very intentionally for these hearings. And there's a video on there, maybe an hour-long video that explains our mapping process, why we do it this way, the scientific reliability behind it. And then there's a whole bunch of attachments that you can download of different scientific journals and different reports from other experts that corroborate and support what we do mapping-wise. And that's the whole reason we made this website, is so when prosecutors like this call me and be like, okay, go watch this video, download this stuff, here's what you need for your case. Mm-hmm. It's a Zoom one. I've got to testify via Zoom. I'm not going to sit here and explain what is about to happen and just tell everybody, trust me.
That's good. Nobody
It's never
should
a good
trust
sign. No,
anybody.
no, don't trust anybody. Everyone is suspect. So we're going to put transcripts, different things that I'm about to talk about are going to be in the show notes down below. We're going to have links. Anybody can go in. I'm going to put my transcripts of what I said in this hearing publicly available.
Oh,
Anybody.
interesting. You're being transparent.
Extremely transparency, because transparency is what wins the day. If there's nothing to hide, there's nothing to hide.
What a concept.
Right. So hearing number one, we're going to talk about how this hearing starts by the seventh question from the prosecutor. And when I say the seventh question, you have to remember the first two are, what is your name, and spell it. So
That's pretty easy.
Yeah, it's going to happen pretty quick. Within probably the first minute or two, we get into my education or background. We're going to talk about this a little bit as we go forward here. I have an associate's degree.
The world knows now.
You have no idea how many times I've been on crazy, super high profile, ridiculous murder cases, and the focus of my testimony has been on my associate's degree.
I know, but our socialites don't know.
Yeah. Okay. So I have an associate's degree. And you know what? I probably have enough college credits that if I just went back and combine them all, I could probably have a bachelor's next month. Mm-hmm. But I'm busy. And I'm not going to go get a degree in a field that I'm not working in. So long story short, I have an associate's degree. I testify within the first 7 questions. I have an associate's degree. We get into radio frequency, cell phone network engineering, other training and experience I have. And I was asked, what other experience do you have? And I droned on for probably 3 or 4 pages. People can read it on their own. So I feel like I need to explain just a little bit. I'm going to try to make it really quick. A lot of the experience that I had when it comes to radio frequency, cell phone stuff. Obviously, I've been working with cell phone records for almost 30 years now. Mm-hmm. But a lot of my career was also working with a cell site simulator. And what this is, it's a piece of hardware. It's a tool that law enforcement can go out in the field and find a cell phone. Physically say that phone is in that house, or it's in that apartment, or it's in that room.
And who has access to a cell site simulator?
Well, number one, good ones are well over $1 million. So not a lot of people. It's a law enforcement tool. You have to use a search warrant to use it. It is a very sophisticated piece of equipment because you have to mimic the cell phone network perfectly in order for it to work. So you have to go out in the field, you do what's called a survey, and you look at how that cell phone network is working in a particular area you think this phone may be at. And then you replicate that network, for lack of a better term, and I can basically create this fake cell tower that looks like it belongs. I drive around, this fake cell tower is now in my truck. I drive around, I get close enough to your phone registers to my fake cell tower, and I can actually start to figure out where your phone is at that point. It takes a lot of work to do it well. I mean, yes, you can just go through the motions and try to get lucky, or you can really study the call detail records that we're looking at to figure out, okay, I think this phone is over here. I'm looking at the area over there. I think that phone, if it's over there, would be using this frequency, probably this channel. And I can get better and better the more I do this.
Well, and to continually get better and do it well, you have to be able to have that type of experience in multiple different types of environments.
You do. And I tried to count them up. I've probably have done this over 3,000 times. I've done it a lot. I've done it so much that one of the larger manufacturers in the world, we actually worked with them for several years developing this piece of equipment to work in the United States. So when I say I've done it a lot, it's not just me running around as a police officer. When I left law enforcement, I've actually worked with the manufacturers who build this equipment to refine it, to make it better, to make it recognize U.S. frequencies.
As in actually understanding not only how frequencies work in Europe, but also how they differ in the United States.
Correct. So a lot of, and again, the transcript is there. People can download and read it, and I get into details with all of this. We also worked with a company called DRT, which is Digital Receiver Technology. They were bought out by Boeing. And just another interesting thing with Boeing, in 2015, you probably remember this night.
I do.
I think it was June.
In Washington, D.C.?
Washington, D.C. I might have been in a pub. I might have had
I might have been in a separate pub than you that night.
We were. You were hanging out with some friends, and I was hanging out with some people that we were working with, and I might have had maybe a beer or two. And I don't remember the date, but it was the day that somebody flew a drone onto the White House lawn or to the White House, and everybody was freaking out about this drone getting to the White House.
It was on the news in the pub.
Yeah, and one of the guys that I was working with, and we were all doing work kind of in this field, he's pointing at the TV and he's like, whoever solves that problem, whoever can figure out drones, that's where it's at. And I was like, well, shit, we can track a drone? And he's like, you guys can track a drone? I'm like, we can track a phone, we can track a drone. We had a couple more beers, we went home, I didn't think much about it.
Conceptually, it's all the same.
Yeah, I don't know, a month or two later, he calls me and he wants to have a call talking about this drone tracking thing that I can do. And I'm like, okay. Well, I accept the call. It's with the head of the NFL security. And the FBI has reported a possible concern about a terrorist event for the 2016 Super Bowl because it's one of the first times the Super Bowl in quite a while has been in an open air stadium. The San Jose Stadium is not a dome. It is actually open air.
And you panic a bit.
I panic a bit because that call turned very quickly. The NFL needs a drone detection protection system for the Super Bowl, and apparently
you're the guy that can do
it. Yeah.
Not only you're it, but the NFL is being told by a very profitable large corporation that you are the guy to do it.
A multi-billion-dollar company is saying, nope, this is the guy you want. And I hung up the phone. I thought, oh shit.
I remember getting the phone call because you panicked and were telling me everything that we need to start ordering under some shady pretenses at that point in time because they were, I couldn't get them legal anywhere.
I don't think the statute of limitations is up, so maybe you should just stop there. Let's just say we bought a lot of stuff that is hard to get.
On my credit card?
Yeah, well, I needed plausible deniability. So and when I say me and one other person that I worked with at ZetX, we built a drone detection system over the next 6 to 9 weeks. We deployed it in the 1st of September to San Jose Stadium. I think we did 5 or 6 college games. We did a monster jam, did some concert, and when we were just refining it. And by the time the Super Bowl ran around in 2016, we had a fully developed drone detection system deployed in that stadium.
Well, what was great is that through that process, we got to work with amazing, huge corporations that partnered with us and really started creating other investigative work products into what we did because it was all API compatible.
Yeah, it was a joint project with us
phenomenal.
And 3 other big companies, and it went really, really well. And I'll throw some pictures up. I don't have them for this, but I'll throw some pictures up. I've got pictures of the Super Bowl. They made me a nice little plaque and everything when I got there. It was cool. It worked. Everything worked perfectly. And we kept on the phone stuff. I wasn't really sold on the drone piece being a good business plan. I'm still not. It's interesting.
No one's ready for the cost of what it actually takes to purchase a drone detection system.
It is extremely
including
expensive.
The NFL.
Yeah, for one that really does what people want, it is incredibly expensive. So long story short, the only reason I get into these things is I will get attacked about my education all the time. Oh, you have an associate's degree. How could you possibly know anything? You stupid caveman, right? Like I get that every time.
Well,
so
Bill
I have
Gates didn't have a degree.
Yeah, but I'm no Bill Gates. The point of that testimony when people read through that is I have to explain a little bit of training and experience of, hey, granted, I have an associate's degree, but I have significant experience in this particular field.
Well, it's interesting that you're saying that because I was actually looking at how people receive honorary degrees from different universities. And some of these universities' guidelines for that, I think you meet.
Oh, a lot of them are giving now work credit. So if you can show, hey, for an entire career, I've specialized in this field, I'm telling you, I could probably have a master's next year if I wanted it in some of these fields. But I don't want it. I have other things to do. I don't care about that.
You're actually busy doing the work.
Yeah, I'm busy doing stuff. So that's what the first part of that transcript, and people can read it for themselves. I'm asked multiple times, do you have a degree in engineering? I say no, I do not have a degree in engineering. I have an associate's degree. It's throughout the entire thing. On page 11 of the transcript, there's going to be a question asked, has Trax ever not been allowed in court? Has Trax ever had a hearing where the judge said, we're not going to allow it? And people can read it for themselves. There's 2 times that this has happened prior to the Jones case. Newsflash, I agree with both of them. In fact, not only do I agree with both of them, people would find if they did a little bit of research, that choice or that decision by the judge was largely impacted by my testimony. One in particular is a case out of Everett, Massachusetts, and I was handed an exhibit similar to what I showed earlier, a different case where somebody had misused the program. They created this exhibit and they were trying to say, see, he's there.
I want to clarify. When we say somebody misused the program, it's not that they went and pressed a button wrong. It's the best practices that they used from an investigative workflow that creates misuse of the program because it becomes very impartial in the way that the program is used.
Right. They take the output and they manipulate it somehow.
There's cherry picking of what they want to show from the output of the data. But that isn't just a Trax issue. That can be done in any mapping platform.
Absolutely. It is an investigative issue. And if people go back and review that testimony that I did in Everett, it's very similar to Jones. The first time I'm seeing really any details about that case is when I'm on the stand testifying. The defense had handed me an exhibit very similar to this case. And when I looked at it on the stand, I actually testified, this is very problematic. If this makes it in front of a jury, nobody in the courtroom did their job. No, this can't be used. And the judge said, no, it's not going to be used.
And just for clarity, you were saying that because you were there solely to lay the foundation of Trax and how it works.
Correct.
Not the investigative pieces of the case.
That is correct. The scientific reliability of cell phone mapping and the mapping specifically that we created with our program. Yes, there's 2 other cases, but in both of those cases, there wasn't issues per se with the Trax program. It was issues with either the foundation or other things. And in fact, the second case, which was also in Massachusetts, Trax was still used. And that's what people don't realize. We still use the Trax program in that hearing or in the trial. So I talk about both of those. It's on page 11. People can read it for themselves. So then you can jump through to page 14 and we actually get into the algorithms or the formulas that we use. And you'll see in my testimony that I've provided this testimony over and over again. I think I've testified on cases like this. It's got to be almost 30 times now. So this isn't some secret testimony that's never happened before. There's a long history of this. You'll see that I state it's not proprietary. I see that all the time, that our system's proprietary, and that's why it shouldn't be allowed in court. It is not proprietary. We have put this out over and over and over again. We've published it online. We've created classes that are publicly facing. We're very transparent, very transparent. It's testable, and that's the biggest thing. If you think that there's a problem with the program, you can test it, and we explain how to test it in that standard.ZetX.com. Not only shows you how to test it, we provide you some sample data that you can play around with and test yourself. That's all covered in 14. We get into the background of that. And then I actually demonstrate how we go through that process. And it's on page 20 of the transcript. What'll be interesting is if anybody jumps to page 20 and they read my testimony, you're going to see, for example, in this case, somebody could have done blah. And I explain how it could be tested in the case I'm testifying. Now, I'll say it again. I don't know anything about this case. I haven't seen any of the exhibits. I haven't seen the mapping. I'm just there to talk about how our program works.
Sure.
But in my testimony, I actually explain how they could test the accuracy in this case. Hold that thought.
Which they never do.
We're going to come back to that. Page 24, we're going to get into the intent of testimony and how law enforcement uses these records. I talk about best practices, and this is really important. I actually testify in this hearing. At no point should somebody take just this static shot of mapping and say, see, here's all the evidence we need, and run with it, which is exactly what's happening in the Jones case. So if people really wrap their head around the Christopher Jones case and you look at my testimony, it's actually really supportive for Christopher Jones.
How did the judge not start putting this together between your testimony and a terrible investigation?
we'll get to this. The point on page 24 when people read it is I explain what was happening in the Jones case shouldn't happen. I just didn't know it was happening because I hadn't seen the case. But I also explain ways to corroborate the records, why that's important, and I get into detail about the mapping the tracks program provides. It's just a rough estimate. You can't just take that picture and run with it, which is what was happening. On page 28, something very interesting happens, and I've testified it's got to be 100 times at this point, if not more. On page 28, the judge starts to interact. And I've had judges ask me questions, and the transcripts won't do this quite the justice of what it is. He almost becomes adversarial. Like he's asking me questions directly that neither the prosecution or the defense asked me, and he kind of just takes over the hearing.
Okay. Almost
Argumentative, like, well, you understand that's a problem, right? And I've never had a judge do this. It was just weird. And I was like, ooh.
What was he arguing that there was a problem?
He didn't agree with our algorithm. He made it very, very clear. He thinks that our algorithm is complete bunk. It's trash. It should not be relied upon. And it just, I don't know what I'm talking about.
Because he's tested it?
No, in fact, later on, he'll go on and say that it's not the judge's job to do that, but that's exactly what he's doing. On page 34, you're going to find me referring the judge to standard.ZetX.com. And at one point he asked me, like, is there any publications that I can refer to? Where do you get this? And again, I refer him to standard.ZetX.com. I referred him there 3 times in my hearing. Okay. Hey, here's all the documents. Here's the video. Here's everything you need. Again, I state I have an associate's degree. So it comes out I have an associate's degree. I'm asked, do you have a degree in engineering? No, I do not have a degree in engineering.
Well, and I also think when you say standard.ZetX.com, it's a very specific URL to give to somebody.
You would think so. A couple of things I think are just interesting if people want to look. Page 37 of my transcript, I get into drive tests, the importance of drive tests, but I also state I haven't seen them in this particular case because I don't know what's happening in this case. I'm just there to talk about the program. Pages 39 and 40, the judge is being really particular about other experts or other scientific engineers, if you will, in this field that have done similar things or anything even remotely close to what we're doing. I actually pointed out the defense expert on this case, who has a PhD in electrical engineering, has done the same thing. And I named the case, and I even told the judge where he could find the case, standard.ZetX.com.
And that was the Merritt case.
That was the Merritt case out of California. Page 43, and this is when the judge takes over questions completely. It is weird. Like I said, I haven't seen a judge do that before. I thought that's kind of interesting. I've never had a judge really take on this adversarial role with a witness before. Let's talk about the judge's ruling. So the hearing's over, and the judge is going to rule that I am not credible. The tracks program is complete trash. And how do I even make an appearance in a courtroom with my lack of education and clearly my just zero credibility in this field?
So there's this elitist academia persona coming out of the judge.
He goes straight thug. The way he wrote this, I've read a lot of rulings that
he took off his robe and like he has neck tattoos.
He went straight thug on this ruling. Like he came out and just completely filleted me. It's pretty harsh. So I want to talk about that for a minute. Let's talk about how the judge is going to justify his ruling. On page 5, he starts listing people who have come out in opposition to my methodologies and practices. And he actually, quote, despite overwhelming criticism from the scientific community, and he's basically saying that the tracks program has got a lot of usage in law enforcement despite this overwhelming criticism from the scientific community.
Who is the scientific community he's talking about?
Well, he goes on and he starts stating all these papers he's finding. So Victoria Sachs wrote this paper, Thomas Kirkham. They're throughout his entire hearing.
Who are those people?
Most of them are defense attorneys.
They're not even engineers.
Not engineers. So he's attacking me because I'm not an engineer. So how can my testimony be accurate? But at the same time, the people that are writing papers in opposition, and it's opposition to cell phone tracking, period.
Not just tracks.
Has nothing to do with tracks. And you're going to find a reoccurring theme here in a minute. But he's relying on other defense. One of them is a graduate student, Aaron Blank. He cites Aaron Blank's paper, who's a graduate student working on a thesis.
Who's never done an investigation, who's never been in trial, who's never seen a courtroom.
Correct. And I should explain, he wasn't an electrical engineering student either. So,
well, and defense attorneys are always going to shun cell site location information because with that information, it is damning. They do not want it in the courtroom.
Correct. He then states that ZetX employees drive around and eyeball the accuracy of our mapping using drive tests.
What? Wait, the judge said this?
The judge says this. And this is where I'm going to start telling people, hey, if you're really interested in this, dig a little deeper. All of these things are published. You can open up Word programs. You can open up PDF programs to do word search. Search the word eyeball. In my testimony, search the word eyeball in the judge's ruling. You're going to see the judge quote me that ZetX employees drive around in eyeball coverage areas.
He definitely already made up his mind that he did not like you.
He does not like me. He does agree that it's testable, but then he just completely, there's no way we can support our testability. And what we say is, hey, in all of our testing, we see a range between 94 to 96% accuracy. And you don't have to be 100%. There's very, very, very little limited evidence in this world that is 100% accurate. So we just have to say, no, it is testable. There are a known error rate. And we talk to that. And man, he just hammers me. And he says, quote, I claim to be an engineer. In spite of the fact I made it very, very clear, I have an associate's degree. I'm not an engineer, but I have done a lot of engineering work. And I explain, I probably have done more engineering work than most engineers in this field.
You have.
Radio frequency engineers do not take call detail records, go out into the field and try to find a cell phone.
Well, because it's an investigative process.
Correct.
It's not an engineering process.
Correct. He hated that I said that. He felt that that was me overinflating my credentials and that I lied about being an engineer. This is where it gets really interesting. He starts to cite a litany of articles to support his case. None of them are from radio frequency engineers. Okay. And it's just, it gets so absurd. And I'll probably throw this slide.
I want to hear about these.
No, I'm not going to go one by one. I've got a slide right here that I'll break down of all the people that he cites. 2 of them are engineers. The 2 engineers that he cites, I actually have work product from both of them on standard.zx.com that you can download that is showing the exact same methodologies that I use in their own work product. And that's the only 2 engineers he cites. Everybody else he cites has nothing to do with electrical engineering. And I'll just put this slide up on the screen so people can look at it individually and you can actually do your research.
The majority of them are all criminal defense or attorneys.
Weird. This is where the wheels completely come off the wagon. And I hope people have stuck around to this point. After I say this, you can go get your sandwich and take the rest of the day off. The judge is going to cite 3 cases that support his opinion that my methodologies and the TRACS program have been thrown out of court before, and they support him throwing it out of court as well. Are you ready for these 3 cases?
Yes.
Let's talk. U.S. v. Evans. This is a federal case from 2012. What was I doing in 2012?
You were a cop. We didn't have TRACS in 2012.
I had not left law enforcement. I had not created TRACS. The business, ZetX, hadn't even been formed.
But it was rejected.
Any idea what law enforcement agency might have been the agency that actually created the work product in U.S. v. Evans that was suppressed?
Well, it's a U.S. v. Evans, so it had to have been the CAS team, the FBI CAS team.
The FBI Cellular Analysis Survey team, the CAS team. The judge cites an FBI CAS case that resulted in a suppression as my case. And I think everybody, including...
Is your name even mentioned anywhere in that document?
No, I'm a dumb cop in Gilbert, Arizona at the time. I have nothing to do with any of this.
He used U.S. v. Evans to say that TRACS.
Yes. So let's move on to the next one. U.S. v. Hill. What does it tell you? That it's a U.S.
It's another federal case.
It's another federal case. Guess who?
Cy-Ray is the culprit.
I'm the culprit.
You are responsible for everything going wrong.
FBI CAS case. Again, so 2 of the 3 cases that he cites as, look, this is why I don't agree. He's had these issues before. His methodologies are screwed up. It's the FBI CAS team that he's actually citing. It's not me. It's not TRACS.
Oh.
Let me give you the 3rd case because it gets better.
The FBI must love you being their fall guy.
I think the FBI CAS team will agree. I had nothing to do with their cases and they had nothing to do with mine. Now, I want to make it really clear. I have worked with the FBI CAS team. I have several cases now that they have testified to what they did in the case. I've testified to what I did in the case, and we both present our cases together as part of the prosecution case. So we've had cases that have overlapped, but I don't work directly within the CAS team, and the CAS team does not work directly with me. So I think everybody can agree these 2 cases out of the 3, so we're already at 66% of the cases he's citing is complete nonsense.
Well, I think historically your work, when you do work with the CAS team on specific cases, it's both of the work products coming together that actually create corroborative evidence.
Correct.
There's 2 different styles of presenting that show the same evidence.
Correct. The CAS team will do a great job looking at specific details within the phone records. What the Tracks program was really good at is taking multiple phones, tons of data, putting it all together and displaying it in layman's terms that anybody can understand. So the CAS team would come in and do the original investigation. We would take that information and we would build it into these animations that we could present to juries. And it worked really well together. We've had a lot of success on those cases. But let's move on to the third. So remember, the judge is only going to cite 3 cases to support prior cases where the courts have rejected my methodologies in the Tracks program.
US v. Evans, US v. Hill.
Which are both FBI CAS cases, nothing to do with me or the Tracks program. Okay. The third one is People versus Valdez. It's a California case. And I'm going to give it to the judge. At least he got a case this time that Tracks was used in. So, hey, at least he's there.
Now he's tracking.
Yeah, but guess what? Tracks was not thrown out. Tracks was used in that case. That case was appealed up to the California Supreme Court, in which, again, it was upheld. It wasn't rejected by the court at all.
It was accepted twice.
And the judge actually says, well, they didn't reject it, but they highlighted the shortcomings. No, they didn't. Anybody can go to People versus Valdez. I'll attach it to the show link too so people can read it. They didn't highlight Tracks' shortcoming. And what Judge Villaseñor doesn't explain, and I know because I testified on these cases, this is a case out of Sacramento, California. We've had so many Kelly hearings in Sacramento, California district courts that it is now precedent. The Tracks program is assumed to be reliable because of all of these cases we've already done.
The judges don't even want to hear about it anymore.
Right, they're done with it. They're like, we've already fought this fight. We know it's reliable. It's coming in. And Villaseñor actually picks one of those cases because he can't find any others. Mm-hmm. And he says, see, here's another one. They didn't reject it, but they highlighted the shortcomings. No, they didn't.
Guy.
He just isn't supporting what he's saying. And I'm going to go a little bit further here as we start to go through there. He then gets into that, hey, there's just no place in science for this. Nobody uses this shape. You'll see in my testimony, I actually tell the judge it's going to be really hard for him to read any articles on radio frequency that he doesn't see the shape that we use. Mm-hmm. And I'm going to skip to a bunch of stuff. That's standard.ZetX.com. It's still up. It's been up since I think we started that in 2018, maybe late 2018, early 2019. Yeah. I cite it 3 times in my testimony. The judge actually says he couldn't find it.
Maybe he needs a degree in search engines.
I don't know. I can't. Let's circle back to accuracy. I say it could be tested. The judge agrees it could be tested. Mm-hmm. What do we have in this case?
GPS.
We have GPS data.
You can corroborate it.
We can corroborate it. Nobody did, which is painful for me to understand or watch as this played out because I didn't know about the case. Remember, I didn't know about the case. So I see this.
Are you saying you also didn't know about the GPS?
I didn't know about the GPS data until the day of the hearing. When I'm in the hearing, that's the first time I've ever heard about the GPS data. So this ruling comes out. I'm a terrible person. I'm a liar. I have no credibility in the court.
You don't have a degree.
He can back it up because CAS cases. So
that you were never involved in.
And I'm reading this ruling and I'm just thinking, this is such a load of crap. Like he literally misquotes me throughout. And again, I'm going to provide the ruling. I'm going to provide my transcripts. People can read it for themselves and see this. Don't trust me. Test me. Read it. But then I got pissed and I thought, hang on. I want the GPS data. Tracks is testable. We have GPS data from the FedEx truck. What would happen if we took the GPS data and we overlaid it with all the Tracks data and we actually tested the Jones case for accuracy? Mm-hmm. It's easy to do. And what I mean by test for accuracy is I can take all the GPS locations. They have a time and date stamp. I can take all of the phone data that has those overlays and I can line up the ones that correlate to each other. So I can say, hey, at this date and time, we know that the phone connected to this tower. Here's what the overlay looks like. Here's a GPS hit from the same time period. Is it inside that shape or is it outside of that shape? And we can actually see how often is the GPS outside of the shape we're putting on the map. And it is 100% testable. There's an interesting issue that happens in this case, and I'm going to show a picture of it so people can understand here. It might be hard to see from where you're sitting, but I've got one of these overlays on the map. And then kind of right down in the bottom center, there's some red dots. And there's some in a parking lot just outside of the shape. And then there's one like right on the line. And then there's some... If I populate all the dots, there's a handful inside. That's the FedEx facility that Jones works at.
Okay.
So this is an interesting thing where he parks his truck at the facility. So we're getting the GPS of the truck in the parking lot.
Sure.
But the building, which I believe he's in, is inside this building that's inside of this shape. So,
and it's just kind of outside the estimated coverage area.
Right. And the only reason I want to show this slide before I say what I'm about to say is I'm going to give this case the benefit of the doubt. If I look at when his FedEx truck is parked at the facility, and I assume, nope, he's in the parking lot for the hour and a half or 2 hours that he's at the facility, just sitting in his truck. So we're just outside that shape. We have a 92% accuracy rate throughout the entire records of the Jones case. If I use a little bit of common sense and I say, hey, he didn't drive all the way to the FedEx facility, just sit in his truck for 2 hours and then leave. He's probably in the building doing stuff with the FedEx packages that are in the building. It dramatically changes the accuracy to 97%, which is actually better than what I testified to. The expert on this case, Poff guy, Pfoff. He's out of Colorado Springs, Colorado.
And Poff pops up a lot in your life.
Oh, he's a mess. He testified a few cases after this one, after I did this research, and I had the prosecutor ask Mr. Poff, hey, did you ever do a comparison on the Jones case to see how often the GPS was inside those overlays compared to outside? And he says, yeah, I did. It was like 50-50. I emailed him and told him he should probably recheck his stats. We then had him on a second case after that.
You told him, hey, out of professional courtesy, I would really appreciate if you rechecked your analysis regarding the accuracy of tracks and how you came to a 50-50 conclusion. To which, by the way, he did not email you back.
No, and in court, when he was confronted with that, he actually said that he was offended by it because I demanded that he change it. But then they followed up, well, have you looked at it and what did you find? He said, yeah, I was wrong. I probably shouldn't have said 50-50 because it's not.
Because he would have perjured himself on the stand.
Right. But what's interesting, and I'm happy to, if people want to look at it, hit us up. I'll send you. It's a Google Earth file, so you have to learn how to use Google Earth a little bit, but there's nothing to hide here. I'll be super transparent. In the case, the Colorado v. Jones case, the accuracy that the judge throws out can actually be corroborated by that case as better accuracy than what I testified to.
This is so crazy.
It is, and people don't realize this.
I'm wondering if maybe with all of the links, you include a KMZ file.
I can include it. If people get in there, it's Google Earth. You'll have to figure out how to use this little timeline slider that allows you to move around, but it's pretty easy. Now, remember, we'd sold the business. We weren't sure what we were going to do, and I got roped into this case, and I thought, okay, I'm done with this stuff. I'm just tired of court. I hate court. I'm sick of it.
You're always picked on.
Yeah, I'll be there for some very egregious crimes, and I'm the bad guy in the court because Judge Villasenor thinks that I'm a liar. And I just got to the point where I don't want to do this anymore. However, every defense team in the country jumps on this case, and it really pissed me off. So I thought, all right, screw it. I'm coming back. And I went on about an 18-month road trip of testifying throughout the United States. And I think this is really, really important because, again, don't trust me. Don't trust what I'm saying. Look at the facts. I'm going to put 2 slides, and I'm going to put these on the screen as well. These are scientific challenges of the TRACS program and me as the founder and the inventor in my methodologies before the Jones cases. There's 15 of them here. TRACS was upheld in every one of these cases. After the Jones case, here's all the rest that were upheld. And when I say all the rest, I want to make something really clear. These aren't cherry-picked. Every single case in the United States, whether it's state court or federal court, after the Jones case, TRACS has been found reliable. My testimony and my credibility has been found reliable. Not only has it been found reliable, there have been judges that have actually spoken out against Judge Villasenor in their rulings. One in particular who stated, I don't know where he got what he got to make that ruling.
So what you're saying is that Judge Villasenor was unreliable.
I don't want to say that because I do believe in court decorum.
I'll say it.
Yeah, but you can say it all you want. But here's the great thing. I don't have to say it. Don't trust me, folks. Get on Google, Colorado Judicial Performance Commission. Google it. In fact, just Google Colorado Judicial Performance, Judge Villa, V-I-L-L-A, Senor, S-E-N-O-R. Commission has been concerned that Judge Villasenor inconsistently applies laws and rules giving varying sentences and similar cases. He inconsistently applies laws and rules. You mean like contributing FBI cases to me?
That could be one.
Yeah, Judge Villasenor's communications have been demeaning, biased, and disrespectful towards attorneys and litigants. Remember when I said when he started going off, like I just have never dealt with that. I've never had a judge take an adversarial approach during a testimony like that. It was just really weird. So I think it's important for people to say, like, yeah, I'm kind of bagging on the judge at this point, but I'm not the only one. There's history here. And I think you have to look at this whole thing in totality. There's no doubt he misquotes me. The transcript is there. The ruling is there. People can search that for themselves. He's quoting sources that are not qualified to make the opinions that they're making. And most of them are just legal arguments. They're not based in science. And I do believe in science.
Science, not
science. Thirdly, he is supporting his case by attributing these cases to me and the TRACS program that has nothing to do with me. It's FBI CAS team that he found cases on that had been thrown out of court for their methodologies. It's kind of interesting. Overwhelmingly, throughout the country, the prosecution has agreed with me that that case is just a bad case. And you know what? I think it happens. Sometimes we get judges that make bad decisions. And in the course of making those bad decisions, they make it worse by citing things that aren't relevant and then misquoting testimony.
Well, they fail to look at the totality of all of the evidence, all of the investigative process, in addition to what they're trying to establish is reliable or not.
And I've had people ask, like, hey, you know that's going to come up when you testify next time. And I've kind of gotten to the point, let it. I like when it comes up because it's such a great example of, hey, my work stands for my work. I can defend it all day long. And in spite of this, if you actually look into some of these details, it's very easy for me to explain.
Which other judges after Villaseñor have done. And they've done extensive research into that case and taken it into account with what your credibility is on the stand.
And if anybody is watching this and they're like, well, how does a judge like this get away with this? Like, what other things? He did recently have a murder case come back, which was a little bit disturbing because it's something that I really haven't seen before. They convict this guy for murder, goes through the appeals process. Both the defense and the prosecution agree it has to come back for another trial.
Why?
Because Judge Villaseñor screwed up.
He screwed up so bad that the state actually recognized this judge screwed up.
After the state convicted this suspect for murder, the state said, no, reverse it. Let's go back and do it again. He shouldn't have said that to the jury.
We do not want to be attached to this judge's decisions.
Yes. I mean, that's strong. That's powerful. It's rare that we see defense and prosecution right out of the gate after a conviction being like, oh, we got to redo it. You screwed it up.
Oh my gosh. And this guy is still a judge.
He is still a judge. But if you're sitting at home, especially if you live in Larimer County.
Larimer.
I feel like if you're out in the county, you could be like, Larimer County.
Stop. Don't do that.
Okay. So anyway, if you live somewhere in the Fort Collins area, in that greater county area there is an election coming up. Judge Villaseñor is an elected position. He was appointed to the bench in 2018 in the absence of another judge. He was never voted in to start with. He was appointed because this other judge left.
He was a fill-in.
His first actual chance to be elected to that position, to the bench, is November of 2024. So to the great citizens of Colorado, well, specifically that district, let your voices be heard. There is an election. And you know what? Elections have consequences. And I hope people do a little bit of their own research with this as well. It's all out there. It's very public. There's nothing really for me to just don't take it on my word like I've been saying. It's out there. And, I want to conclude with takeaways. I'm bagging on the judge quite a bit here.
Yes.
I've reviewed this case over and over and over and over again. I could have done better. I read my transcripts and I cringe at a lot of it because I'm like, oh man, I should have been more articulate here. I should have done better here. So I do want to say that, hey, I'm taking a little piece of the pie here too. There are pieces in my transcript that I would clean up if I had the opportunity to go back and clean up. I think I could have probably done better in preparing the prosecutor, who is just completely unprepared. The prosecution was a mess on this case.
Right.
The other thing, and I actually enacted this rule, if you will, I will no longer get involved with a case, even a scientific challenge, without reviewing the actual investigation. And some agencies are like, no, we don't need you to review anything. We just want you to testify about your methodologies, your training. And keep in mind, people might not realize we've probably trained thousands
30,000 cops.
more. Yeah, that have come to conferences or come to our courses. We have, I think, over 100 subject matter experts now that we've trained and that are recognized as subject matter experts. So I have to testify a lot on the methodologies. We created best practices within this field that I have to defend on a regular basis. So a lot of times I'll get these phone calls. Can you just come in and testify to the foundation of this training and the processes? And I won't do it anymore. If I get involved in the case, I demand to see the investigation. And then I make the decision of whether I want to get involved and who I'm going to support. Because there are times like the Jones case that if I would have reviewed that case before I testified, I would have supported the defense. I actually would have come out and said, hey, I need to support Christopher Jones here because the state has it wrong. And I can show you why it's wrong. And we can fix this. So that's something else that I've changed.
Assuming you don't get a biased judge.
Right. But at the end of the day, I think it's important to note, even in that situation, I feel like I was kind of unduly categorized by the judge there. There are things I could have done better, and there's things that I'm doing better in the future. So there is something to take away from that.
It was a really good learning process.
It was.
Take away from what you typically did, because you can't do things the same way all the time and not continually get better.
And I'm not going to lie, it kind of sucks to have those learning processes on a national stage, but hey, just another day.
You're a great scapegoat.
Thanks.
You're welcome.
By the way, if you believe in Judge Villaseñor's ruling and you're like, nope, this Cy Ray guy, he's a schmuck.
Yeah.
Judge got it right. I've got news for you. The FBI CAS team's methodologies are screwed up as well. And I'll leave you with that.
That is interesting. Join us next week for Clown Shoes. Have a great week, socialites. Stay safe.
I need him to remain anonymous. He will sue me. He does not like me. The defense attorney actually said Cy Ray's Trax program is as reliable as Sex Panther cologne, where 50% of the time it works 60% of the time. And the creator, Cy Ray, is just like the sleazy field reporter, Brian Fantana.
And the judge allowed this.
That doesn't make sense.
Well, let's go see if we can make this little kitty purr.